There's something worrying happening in immigration right now. More and more I-751 cases filed to remove green card conditions are receiving denial notices from USCIS lately. And not only that, those cases are taking a long time to process. It is almost unbelievable. People are waiting 2 years, even 3 years, to get answers on these conditional green cards. So, denials are rising and delays are worse. What can you do to improve your chances and make sure you are not denied? Then also help your case move faster with better evidence and prompt responses from day one onward. I made a video about this a few months ago, and this is an updated, expanded version about I-751 denials, what may be causing them, and how you can protect your case too. All the updates and important details are in this video today. Hello friends, welcome back. I am an immigration attorney with 22 years of practice now. In this video, I want to explain why I-751 removal of condition cases are getting many denials, requests for evidence, and notices to terminate in recent months across the board. What can you do to make your cases stronger? And what is going on with the delays in these I-751 filings? And what can you do to accelerate your case? I am going to give you the latest information as it affects cases moving from June through July and all the way through the end of the fiscal year in October 2026. So, make sure you watch this video all the way to the end. So, if you are married to a U.S. citizen and your marriage was under 2 years old, you likely received a green card valid for only 2 years. And the rules say you must file Form I-751 90 days before that 2-year period ends under current rules to remove the conditions from that card, as required now. The green card, which is only good for 2 years, once you file that I-751, you will get a notice, a form. And that form is an extension for about 48 months, with work and travel authorized too. The problem is that in 2026, the stakes are very high. We have never seen so much scrutiny over these I-751 cases. And also, almost every single person is now getting an interview, whereas before, most of the I-751 filings were waived. You did not even have to go through an interview, and you got your removal of conditions automatically in the mail. The recent data from USCIS indicates that over 30% of these I-751 cases are issuing either an intent to deny or a flat-out denial at this time. This is a huge number because if you look at previous years, it was under 10%, even lower when we talk about close to 30%. That is very concerning. Now, that does not mean that all these cases are going to be denied. These people who are getting notices of intent to deny, if you respond properly, in most cases it will still be approved eventually. But the fact they want to deny so many cases is concerning, and I will tell you in a second why that is happening. In addition, most cases are pending for over 30 months, and when something stays pending that long, it creates problems for your case eventually. Why? Because people move homes, and sometimes they forget to update their address, and sometimes notices are sent to your address and you are unaware of it, like a request for evidence. And if you are not responding within a timely manner, your case will be denied later. And this has been happening to many I-751 applicants because who can wait 48 months for a decision? Some people move within a year or two, and that is a big issue right now. Some people also get divorced, which is fine, because when you file a request for I-751, even if you file it together with your spouse, later on if you get divorced, you have to update that form. You have to update your situation, and if you fail to do that, it can create a request for evidence and eventually a denial if you do not correct it properly and quickly. So guys, let us talk about common situations that lead to requests for evidence, notices of intent to deny, and denials. The first issue we see with our clients is address problems early in cases. So, for example, you live together, you file the original case together, but then you move to a different place because of a job or school, and you forget to update your address there. And even if you update your address, sometimes it takes USCIS a while to receive it or update their system, and they are going to send you a request for evidence or biometrics notice, and you fail to show up on time. And that creates a chain reaction throughout your entire case process. So, If you fail to respond to any of their notices, eventually your case can be closed. And once they close it, and once they deny your I-751 while you are not aware of it, you may get a notice to appear in court later. And that is how many people end up in removal proceedings, because they failed to answer a simple USCIS notice due to an outdated address on file today. The second reason some of these cases receive notices of intent to deny is because the evidence from the start was not strong enough. You did not give them enough proof that you live together. You did not give enough proof that you are actually husband and wife. You are living as spouses daily. And weak evidence at the beginning of a case can eventually create a request for evidence, and then a notice of intent to deny. And if you fail to respond properly, that can also lead to a denial. So make sure you have very strong evidence early in the case file ready. Another reason is many people either ignore a request for evidence or fail to respond on time for other reasons. Maybe you worked with someone who helped you file the case, an attorney, then you changed law firms, or that person failed to update you because they requested something, or you submitted a partial response to the request for evidence. And guess what? They will not accept that response. They will deny the whole thing. So, make sure when you respond to these requests for evidence or notices of intent to deny, you answer every single line and everything they ask, because a partial response is almost like not responding fully. And most people are not aware of that. And finally, immigration is checking your background. They are looking at credit reports. They are looking at what you do. If you are telling them that you live at address A, but your other online information shows you somewhere else, or you are posting social media content that could hurt your case, that is going to be a big red flag and could lead to a notice of intent to deny right away, and potentially a denial during this review process too. So make sure whatever you put in the application also matches what it looks like online and on your credit report. In fact, we have developed a tool to help you scan your social media, so make sure there are no surprises. The tool is visafootprint.com. The link is right here. Scan your social media and see if you are risk to USCIS. This is limited to viewers. We just launched this tool today. Test it out. Give me feedback in the comments and see whether your social media is safe. Now let us understand how you can protect yourself going forward. Number 1. Create and connect your USCIS online account. You get notifications from them. No matter where you are, you receive an email when activity appears on your file. This is essential, especially for I-751 cases that are taking forever. Number 2. Always update your address using Form AR11 online. It does not matter how often you move, every single time. Update it and keep records of update. Always file Form I-751 within the 90-day window. Do not miss it, because missing the window can hurt your case significantly later. Build a rock-solid evidence folder now. Have everything to show: joint bank account, affidavits, proof that you live together often, and documentation you can include in the file all too. If you got divorced, file an amendment as soon as possible. But you will not be able to go anywhere until the divorce is final there. Once the divorce is final, update immigration immediately, because you will not get the waiver for removal of conditions until your divorce is final when filing based on divorce alone. And finally, if you get a request for evidence or a notice of intent to deny, always respond to the entire notice and respond within the deadline. And finally, if you receive a denial, it is not the end of the world. There is a way to sometimes refile the case if it has merit, and there are ways to fix your record even after a denial. Remember, the key here is to act fast before a notice to appear in court is issued. Now guys, I am not trying to scare anyone here. I am just sharing facts. The fact is that I-751 processing is slow. We all know that. The fact is that very few people are getting interview waivers these days. More and more people are actually going to interviews now. And the fact is that people are getting denied and getting notices of intent to deny. This all can be avoided. But if it happens, it is not the end of the world. cases can be refiled with proper evidence and proper guidance from an attorney. So if you are worried about your I-751 case, send me a message right here. It is a WhatsApp number, and it will allow you to book a consultation so we can review your case and work toward the best possible outcome so you can still successfully renew your green card whether you are married or filing on your own. Once again, guys, thanks for watching. Watch our up-to-date videos about I-751 in the link down below here also. And let me know in the comments what other questions you have about this topic and other topics. As always, subscribe so you do not miss my new videos. And I see you in the next one.